Good morning, colleagues. A very warm welcome to all who are joining this webinar today on retirement planning. This is our final session of a three-part webinar series on retirement planning. On behalf of the Director General Human Resources, Ministry of the Public Service, and the Director, Learning and Development Directorate, I welcome you again to this morning's presentation. My name is Sheila Grisette, Senior Human Resource Officer acting at the Learning and Development Directorate. I am the moderator for today's session. My colleague, Mr. Mark Hurley, Senior Human Resource Officer, also from the Learning and Development Directorate, is the co-host for today's presentation. As we commence this morning's webinar, please note the rules of engagement for the presentation. As much as is possible, please pause or minimize distractions. We want you to reap the full benefit from the presentation. As the facilitator goes through the presentation, take some time to reflect on relevant issues you may wish to share. We invite you to share your comments or observations or pose your questions using the Q&A icon at the bottom of your screen. There will be a question and answer segment at the end of today's webinar presentation. At the time of the question and answer segment of the webinar, your contributions will be shared with the facilitator, who will then respond via audio. Please also note that today's presentation is being recorded. The recording will be posted to the Learning and Development Directorate's YouTube channel. A message will be sent via email blast to alert you when it is available for viewing. Ladies and gentlemen, please join me in warmly welcoming back our presenter, Mrs. Gail Worrell. Gail Worrell is a seasoned professional financial advisor with a diverse skill set and a commitment to helping individuals and businesses achieve their financial objectives. With half a decade of comprehensive experience in the field, she has established herself as a trusted advisor in retirement planning, money management, risk management, and budgeting. She takes a holistic approach to financial planning, considering both short-term needs and long-term objectives to formulate comprehensive strategies that drive sustainable goals and prosperity. With a clientele of approximately 275 individuals and businesses, Gail has demonstrated her ability to cultivate lasting relationships built on trust, integrity, and genuine commitment to their clients' success. Whether guiding individuals towards goal achievement or retirement planning, assisting families with estate planning, or supporting businesses in achieving their financial goals, Gail provides personalized solutions that align with her clients' unique circumstances and aspirations. Outside of her professional endeavors, Gail enjoys volunteering her time to promote financial literacy initiatives and empower individuals to make informed decisions about their finances. She firmly believes in the transformative power of education and strives to empower her clients with the knowledge and resources they need to navigate the complexities of the financial landscape with confidence and clarity. Pleasant good morning, Gail, and welcome. It's over to you now to begin today's presentation on retirement planning.
Sheila, thank you so much for the warm introduction, and it really is a pleasure and an honor, really, to be here with you all for the third and final episode of our retirement planning talks. So welcome to each of you for today's webinar. We have an exciting session planned, and I am thrilled to see so many of you joining us this morning. Right? Your participation and your engagement in these webinar events is what makes this something to look forward to. And we look forward to having a productive and an insightful time together this morning. Now, the objective of today's webinar is to dig a little deeper into retirement planning by drawing your attention to a few topics which should be a priority in planning for retirement. So this session today will focus heavily on helping you as the participants today understand the components of healthcare and long-term care during retirement. It also covers various estate planning strategies and helps you to understand the components of planning your estate, taking a look at and examining your bank accounts, and the importance of assessing and creating a will document. So that by the end of the webinar, you should have a clearer picture of what you need to do to achieve or start to consider or review in terms of your estate, your bank accounts, and a guide of what to bear in mind for creating your will document. All right. So let's get started. The first component today, which we'll be looking at, is the importance of considering healthcare and long-term care during retirement if it is needed. And as discussed in our previous episodes, as a retiree, generally, an individual needs between 70% and 80% of their previous income or their income from their last job to maintain their lifestyle and manage their monthly obligations during retirement. And retirement can last for many, many years after age 65 or after age 67. More specifically, as we can imagine, our health declines as we get older, and so does the level of our savings accounts. So that this topic now must become one which we must take into consideration. And there are a number of factors that we have to take into consideration where healthcare and long-term care are concerned. And the first one is unexpected costs. So healthcare costs can be significant and can also be extremely unpredictable. And without planning, the retiree may struggle to cover basic medical expenses, right? So to give an example of what long-term care or health care would look like is, for example, nursing home care or assisted living facilities or in-home care services. And many of these things tend to, if there is no health insurance, if there's no healthcare plan, typically have to come out of what we refer to as out-of-pocket medical expenses. Right? So things like hearing aids, things like prescription drugs, things like vision care, glasses, cataract surgery, things of that nature may fall under health insurance, but then there's some other areas which may not be covered under health insurance. All right. Now, typically there are other areas. You may have your dental care, you may have major dental procedures, root canals, dentures, surgeries, extended hospital stays, private treatments, specialist visits, things of that nature, which can be considered as unexpected costs. But typically, these costs can be extremely expensive, depending on the required necessities in terms of financing. All right. Then you have to take into consideration as well the average costs for something like this. So, for example, nursing home care can be averaged at about $50,000 per year. Whereas assisted living facilities, where you may have an in-house nurse or a specialist come in to take care of an elderly individual, and that may be somewhere between or averaging at about $26,000 per year or more. All right. So it is important to take these things into consideration from as early as possible. The next component is increased longevity. So individuals have heard this term many, many times recently, that life is short. And I want to say to you today that life is long and life is beautiful. And longevity, or the increase in life expectancy of individuals, can have significant effects on retirement and retirement planning. So an extended retirement period, or as life expectancy increases, while that is a good thing, there are also some factors that we have to take into consideration, because an individual or a retiree may no longer be living 5 or 10 years after retirement. They may now be living 20, sometimes 30, sometimes longer than that for their retirement period, which means that planning for it financially, it now takes a little bit more to be able to cover in terms of savings, in terms of Social Security, in terms of investments, etc., to make sure that you are comfortable, not just for the first 5 or 10 years, but for the next 20, 25, or 30 years. And because of improvements in medication, in terms of improvements now in, doctors' facilities and long-term care, individuals are able to live longer. All right, but as we can imagine, healthcare costs can continue to increase, similar to the way we were explaining it in episode 1 and episode 2 about inflation, and taking into consideration the higher cost of living. So those are the things that we want to take into consideration when we are planning for retirement. Yeah. Then we have to take into consideration as well lifestyle implications. So what type of quality of life would you want to expect to maintain or focus on maintaining to enjoy during your retirement years? Housing and living arrangements. Longer lifespans may necessitate changes in living arrangements, such as moving to a smaller home, senior communities, or long-term care facilities. That comes with an additional expense. Family dynamics into this category. Longer lives can affect family dynamics, with retirees possibly needing to care for their older parents or relying more on their adult children or grandchildren for support. But then you also want to remain engaged in staying active and taking up either volunteer work, taking up hobbies, and being able to, be productive and fulfilled in your retirement years as well. So we want to take into consideration saving more, diversifying our investments, considering various strategies for increased longevity, financially increasing your longevity, and then planning for healthcare, adjusting your spending, etc. All right, and then we want to take a look here at protection of your assets, because, or you may be asking yourself, how does protection of assets fall under the category of healthcare and long-term care? If you have property, or if you have an investment and your health declines, more often times than not, that asset becomes subject to liability. Because in order for you to care for yourself financially, you may have to very well put that property or put that investment up for sale. All right, so we want to make sure that we are saving from now to be able to protect those assets, or be able to have the asset secured enough that it can become collateral for us to be able to take care of ourselves during retirement. Or you want to make sure that you can comfortably afford health insurance during your retirement years as well. You want to make sure then that you're taking a look at maintaining an emergency fund, right? The emergency fund worth of living expenses, sometimes 3 months, sometimes 6 months, depending on what can be uncovered as an unexpected cost without tapping into your long-term investments. Right? And lastly here, we want to take a look at peace of mind. Achieving peace of mind prior to and during retirement involves a comprehensive approach that includes planning, it includes saving, it includes investing, and managing risk as well. So prior to retirement, individuals, for financial planning, you want to be able to set goals. You want to be able to have or define clear financial goals for retirement, including your desired lifestyle, travel plans if necessary, hobbies, and create that so that you understand what your income sources are likely to be, any expected or projected expenses, and what your savings should total in order to have that level of peace of mind. You also want to reduce debt. So pay down on high interest debt such as credit cards, personal loans before entering retirement. Aim to pay off your mortgage before retiring to reduce monthly expenses. You want to track your spending, monitor and tracking your spending pre-retirement puts you in a space mentally so that you already have built a habit of budgeting and spending, so that when you have to adjust your lifestyle, if it needs to be adjusted at or before retirement, you can make those necessary lifestyle adjustments to increase savings and reduce unnecessary expenditures. All right, building your emergency fund, having a health insurance plan are things that you want to make sure you can maintain that gives you that additional peace of mind as well during retirement. Yeah, so right now what we want to take a look at is a poll. And you know I like my polls. And so this morning we are going to, you're going to see a screen pop up on your screen with a number of questions. And well, sorry, number of answers, one question. So the question for you today is, when planning for retirement, how much consideration do you give to potential healthcare and long-term care expenses? All right. When planning for retirement, how much consideration do you give to potential healthcare and long-term care expenses? And so there should be a drop down on your screen, which enables you to select your answer. And when you've selected your answer, you can hit submit at the bottom. So answer number one will be a great deal. You've given it a great deal of consideration. I have specific plans and savings allocated for these expenses. You've given it some thought about how to start saving, but I may need a little bit more assistance in that area of saving. You've given it minimal consideration. So I know it's important, but I haven't made concrete plans or savings as yet. And I have not considered it at all. Right? Now, you're not going to be able to see when we put the results up on the screen, you're not going to be able to see what your colleague may have chosen. But what you will notice is that you have other persons that are in your category. You have some friends as it relates to where you are at when planning for retirement, how much consideration you've given to healthcare and long-term care expenses. All right, so we are going to show the results on the screen so we have an idea of where you are at. Fantastic. So this is interesting because now many of you on the call may not be nearing retirement. A lot of you on the call, I don't know who you are, right? I don't know what your ages are. I don't know how much longer you have until retirement. So what this says is that you have given it some thought and you've started saving towards it, but you need some additional help. Some of you know that is important, but haven't made a concrete plan with regards to saving for healthcare and long-term care expenses. Some of you have a great deal, have considered a great deal. You have specific plans in place. You have savings allocated for these expenses. And then 5% of you said, I haven't considered it at all. And that's why we are here today. We are here today to show you that it is something that you need to consider. All right, because this is your future. And therefore, it becomes your responsibility. All right. Now, there's a quote that I like to mention, and that is, the longer I live, the more beautiful life becomes. All right. The longer I live, the more beautiful life becomes. So we want to move on into our next segment, which is estate planning. So there are a number of individuals who I speak with on a day-to-day basis who say to me, well, you know, I want to be financially free. I want to have a sizable estate. I want to be able to, you know, transfer property. I want to be able to leave my family with something that they can carry on, they can survive, they will be okay if anything were to happen to me, etc. And so there are a number of components that will help us to do those things when we take a look at estate planning. And so the first thing that we want to consider here is a will. And having a will does not mean that you are going to die tomorrow. Okay, let me just put that myth out there. Let me just clear that myth before we start. Now, a will is a legal document that states how a person's assets will be distributed after their death. All right? A will is a legal document that states how a person's assets will be distributed after their death. And we're going to come back to this in a little bit. A trust is a fiduciary agreement where a trustee holds and manages those assets for the benefit of the beneficiaries, right? And then trust can be set up in a way to take effect either during a person's lifetime, which could be considered as a living trust, or after their death, which is referred to as a testamentary trust. Then we have the other component, which is beneficiary designation. And this is where you're ensuring now that retirement accounts, life insurance policy proceeds, and the other financial accounts, bank accounts, etc., have designated beneficiaries who will receive the proceeds or the assets directly bypassing the probate process. Yeah. Now, the probate process right now is taking quite a while here in Barbados. All right. A source that's been extremely close to me, as I understand it, the probate process is taking about 24 months in order for an executor to be appointed to have a will or assets transferred to the designated beneficiaries. That's a long time for family members to have access to accounts, to have access to insurance policy proceeds if there's no named beneficiary, for bank accounts to be holding on to or freeze or releasing funds from a frozen account. And those are things that we're going to get into in a little bit as well. Joint ownership. Holding property jointly with rates of survivorship allows the property to pass directly to the surviving owner without going through probate. So for those of you who are on the call, and for example, you may be looking to get into home ownership, you may be looking to purchase property, etc., and you are looking to hold that property jointly with someone else, understand that the rates of survivorship avoid going through the probate process. All right, but there's some other legal components outside of that I will not get into today. However, that's just something to note when you're planning your estate. Then we have things like charity and gifting. So donating assets to charitable organizations to reduce your estate taxes and fees. And then things like gifting, reducing the size of your estate by making gifts to family members or charities during your lifetime, potentially reducing any estate fees, taxes, etc. And then the last one is life insurance proceeds, which provides cash, provides the liquidity to pay any legal fees, taking care of any estate charges, etc., and any other expenses, really ensuring that your heirs or your beneficiaries receive the intended inheritance as quickly as possible. All right. Estate distribution. So estate distribution or asset distribution. Estate planning ensures that assets are distributed according to the retiree's wish or the property owner's wish, right? According to their wishes, avoiding disputes among heirs and beneficiaries. Now, what I want to note here is that assets as well as liabilities are included in one's estate. So for example, individuals may say, well, I have property, I have houses, I have chunk houses, I have insurance, I have this thing and the other thing. But what about if you have a mortgage outstanding on those assets or on those properties? What if it is that you have business loans? Whatever it is that you have credit card loans? Whatever it is that you have extended debts on your estate that are in your name. Your estate is comprised of not only the asset, but also the liabilities. So you have to consider those things when you're talking about transferring or diffusing or dissolving your estate. Because the difference between your assets and your liabilities could actually put your estate in the negative, in the minus. All right. So assets are considered as real estate. So house, land, property, etc. Personal property, jewelry, vehicle, artwork, bank accounts, investment accounts, stocks, bonds, mutual funds, retirement accounts, life insurance policies. But it also includes, like I said, liabilities, the mortgages, the loans, credit card debt, taxes owed, any other outstanding debt. You also want to minimize taxes. So proper estate planning can minimize taxes on an estate if necessary or if applicable, preserving more wealth for beneficiaries. Providing for dependents, ensuring that those dependents such as minor children or disabled family members or even parents are cared for financially. You want to also avoid probate, which obviously helps to avoid the lengthy and costly probate process, allowing assets to be transferred more quickly and efficiently as well. Yeah, so those are some of the components that are involved in estate planning. Now, the next component of today's session is bank accounts. So when considering bank accounts for retirees or for yourself at this point in time, there are several legal considerations, particularly regarding joint and singly owned accounts. And so there are some points that need to be considered because there are some advantages and there are also some disadvantages. So for singly owned accounts or individual accounts, the advantages would be that you have sole control. You have absolute control as the account holder over the funds, which can simplify things like budgeting, financial management, spending, etc. The funds are protected from debts and liabilities of others, reducing the risk of losing assets to creditors of a joint account holder. Individual accounts can be more straightforward in estate planning, allowing the account holder to designate beneficiaries to handle the account through their will. And so we will get to wills in a little bit, right? But there are also some disadvantages as well. Because if the account holder becomes incapacitated, or if they were to pass away, God forbid, accessing the funds can become difficult if that individual did not have a power of attorney or any other legal arrangements in place. The probate process for an individual account may need to go through the probate process upon the account holder's death, which can be also time consuming and it can also be very costly. The account holder must also manage the account independently, which can be challenging for those with declining health or cognitive abilities. So I remember dealing with a case about 1.5 years ago where the individual was a working young person, and the mother of that individual became challenged with cognitive abilities. So eventually they developed dementia. They were not able to remember passwords. They were not able to remember bank account information, accessing that account information by way of ATM PIN, that kind of information. And so therefore, there is nothing that could be done in order for the bank to release funds to the son. All right. Had that individual had, let's say, for example, a power of attorney, the power of attorney would have been able to, you know, access or provide the bank with some type of paperwork to say, okay, well, look, they have given me power over the account to be able to withdraw or to be able to utilize a certain amount of the funds every single month to take care of a certain list of responsibilities, whether that's a light bill, the water bill, purchasing groceries, etc. All right. So that's something to consider. Now we move on to joint accounts, the advantages and disadvantages of a joint account. So the first advantage of a joint account is that joint account holders, they both allow the bank access to give permission to the bank to have those funds managed by 2 persons instead of just one, which can be helpful if one person becomes incapacitated or if they were to pass away, so that they both share then the financial responsibility of managing that account. All right, and then survivorship as well, because joint accounts often include rights of survivorship, meaning if one account holder passes away or dies, the other account holder automatically becomes now the sole owner of that account, avoiding probate. And then there's ease of access. So both account holders can access or use the funds, which is useful for managing day-to-day expenses and emergencies. However, there are also disadvantages. So the first disadvantage, as you could imagine, is the risk of misuse, where both parties, by permission, have equal access to the funds, which could lead to potential misuse or disagreements about spending. So we've had many, many cases. I think we've had the minister speak about the misuse or speak about, you know, overspending on a retiree's bank account. You may want to get around that by seeking some type of legal advice on how that can be avoided, right? Going into retirement or before you get to retirement, so that there's someone else that may be able to assist you with spending and taking care of day-to-day expenses, emergencies, things of that nature. The other disadvantage is legal liability. So for example, if one account holder has debts or legal judgments against them, creditors may be able to access the joint account. Now, this obviously would depend on which financial institution the account is being held at. All right. There's also impacts on estate planning. So for example, joint accounts may complicate estate planning if they're not properly coordinated with wills or trust. And we're going to get into wills in a little bit because we want to understand how not having a properly coordinated will affects or has effects on estate planning or has effects on joint accounts, which could potentially then lead to disputes among heirs and beneficiaries. So from a legal standpoint, this is my understanding, a power of attorney, when a retiree is moving away from the working world and they're retiring, they should consider setting up a durable power of attorney, allowing a trusted person to manage their finances if they become incapacitated. They should also have beneficiary designations, right? Where many banks may allow account holders to designate beneficiaries through what we refer to as POD, payable on death, or TOD, transfer on death, which can help also to avoid the probate process. So the estate planning coordination ensures that the banks are, bank accounts are coordinated with other estate planning tools, such as wills and trusts, to avoid conflicts and ensure that assets are distributed according to that retiree's wish. So as a retiree, you should consult with, or before you become a retiree, you should consult with financial advisor, legal professionals, etc., to determine the best approach for your bank accounts, taking into consideration financial situation, health, and your estate planning needs as well. Now we move on to the will, the components of a will, and what is necessary in order to have a properly coordinated will. So what we will look at is the components of a will. So the first one is having an executor. Now, these are the main components of having a will document, yeah? So the responsibility, of an executor is for carrying out the instructions in the will, managing the estate's assets, liabilities, paying off debts, distributing the assets to the named or designated beneficiaries, heirs, family members, etc. So the selection should be someone that is trustworthy, organized, and capable of handling financial matters. As a power of attorney, their role, is to provide a legal document that gives someone authority to act on another's behalf in financial or medical matters. So this can be either a general power of attorney, which gives very broad authority, or it can be a specific power of attorney, which then has limited to our specific task. And then we have durable power of attorney, which remains effective even if the person becomes incapacitated, while a non-durable power of attorney does not. All right, and then we have witnesses. The role of a witness is someone who observes the signing of the will and attests that the testator, which is the person making the will, was of sound mind and not under duress. And so typically witnesses should be disinterested parties, meaning that they should not really be beneficiaries of the will. All right, now the beneficiaries' role, the individuals or the organizations who will receive assets from the estate or even receive liabilities from the estate. The consideration here is that the clear designation of beneficiaries is crucial to ensure that the estate is distributed according to the testator's wish, and any debts or liabilities must be paid first. All right. And then we have guardianship. So the role of a guardian is they've been appointed really to take care of minor children if one or both parents pass away. And that selection process should be someone who is willing and able to take on the responsibility of raising the child or children. All right, and then there's something also referred to as the residue clause, where this specifies how any of the remaining assets, so the residue of the estate, which would be the assets after liabilities or debts have been taken care of, how those specific assets now should be distributed after the specific bequests or the requests have been made and debts have been paid. All right, so finalizing the estate plan, you want to review and update your will regularly. So estate plans should be reviewed periodically and updated to reflect any changes in life circumstances, such as marriage, such as divorce, birth of children, or changes in financial situations. So you may have a change with regards to your occupation. You may have had a change over the last 10 years with respect to bank accounts, maybe an inheritance, maybe, change in not just job title, but also income. All right, and you want to be very specific about communicating with your family members or the beneficiaries your estate plan to be able to help prevent any misunderstandings and conflicts, because these things are things that happen, and then individuals can squabble, they can fight, they can, over an estate. All right. Now, some persons may say, well, I don't want to do a will, or I want to be able to, when I pass away, those who remain will look after that. And I see that as very unfair. Not when it can be prevented. Not when it can be set up in a way that you have control over what happens by doing something as simple as having a will document. You want to consult with an estate planning attorney or financial advisor to help you ensure that your estate is comprehensive and it obviously applies with local laws. Right? Now, there is a scenario where a 65-year-old retiree who has meticulously planned their retirement and their estate, they have a comprehensive healthcare plan or a long-term care plan to cover potential medical expenses. They have a detailed will and established trusts for grandchildren's education, and having, designated bank accounts for beneficiaries, right? In the event that something were to happen to that individual, that their finances can be managed as best as possible. The assets are distributed according to their wishes, avoiding probate and minimizing fees and taxes, so that the family experiences a smooth transition with no disputes or financial burdens. So that financial planning or planning your estate is much like constructing a building with a very solid foundation, so that every aspect from healthcare planning to the will is like a building block, ensuring that the structure stands strong against any challenges. Now, scenario number 2 refers to a retiree who has not planned for healthcare or long-term care costs, has not created a will or established any trusts, but has family members, has grandchildren, has dependents, may have suffered with a serial illness, and medical expenses may have very quickly depleted their savings. So that after their passing, the estate now has to go through probate, causing lengthy delays and significant legal fees. Children and grandchildren and beneficiaries and family members and dependents are then left with unexpected financial burdens. And then you have family disputes over asset distribution. And that's much like not planning an estate, or that's like a sailor planning to go on a month-long trip with no compass and no map. There's no direction, there's been no preparation. And so you then encounter unforeseen obstacles and are ended up in a situation, or a precarious situation, I want to say, leaving loved ones to navigate the stormy aftermath. And so in my field, we discuss, or we have conversations from time to time where we may think, after some person passes away, or after they become incapacitated, or, should something happen to them where it could have been avoided, or it could have been better planned for. Sometimes we say, if that person, or the hands of the clock could be reversed for that individual, and they knew what they were going to go through in the next 24 to 48 hours, I am guaranteeing you that many times, I want to say at least 75% of the time, for those who love their family, they would set up something. They would make sure that a will document is in place. They would make sure that their bank accounts are in order. They would make sure that 10 years, maybe 15 years prior to, there was no debt. Or they would make sure that there are certain things that have been put in place, right, to avoid the probate situation. So that stormy aftermath or the probate process moves from being messy to being a very smooth transition without the dispute or the financial burdens. All right. So I hope that this has given many of you here on the call today something to think about as we plan for retirement. I was speaking to someone, an elderly lady the other day, and she is heading into retirement very, very shortly. She is 63, and she did not think that 63 would, quote unquote, with what she said, creep upon her so quickly. She recalled her 30th birthday like it was 2 days ago. And she is 68 as of March 2020. She is 63, sorry, as of March 2024. All right. So life moves, life happens quickly. Things come, things go, but life is long. And I want you to remember that this is your future and this is your responsibility. So to recap, I want to encourage you to take steps to consider your healthcare options. Take steps to investigate the costs so that you can plan. Take a look at what some of your long-term care options are here in Barbados. Maybe options that may be closer to you in terms of proximity to where you're currently living, etc. That's one. Secondly, I want you to review your estate, any potential assets, any potential liabilities, any current assets and current liabilities, and assess strategies to ensure that those can be transferred smoothly or dissolved without becoming a financial burden to a family member, to beneficiaries, to heirs of your estate, to parents, to grandparents, to children, etc. Thirdly, understanding estate planning from a banking perspective. Ask yourself, who will have access to my accounts? Who will be my named beneficiary or beneficiaries? Will that be someone who will outlive me that I can trust? Might I need a power of attorney? Right? And lastly, we discussed the importance of having a will. We review the components of what is involved in creating a will document. All right. So I encourage you to seek legal advice, right, from an attorney to assist with the process. And what I did not know, I found out probably about 2 years ago. Some individuals, were saying, well, a will is expensive. Some of these things cost a lot of money. But a basic will can start at about $250 plus VAT. All right, that's a basic will. Now, obviously, for individuals who may have a larger estate, they may have a lot of assets, maybe limited liabilities, a lot of family members, sisters, brothers, uncles, aunts, grandparents, children, grandchildren, etc. They may want to leave assets and leave different things for different people. You may have a collection of vehicles. You may have had, a number of things that may need to be a little bit more than the basic. It may be a little bit more intrinsic, or it's a little bit more, some more details that may need to be added to the will. Bank accounts, retirement accounts, retirement plans, insurance policy, proceeds, things of that nature. It may be a little bit more than a 250 plus VAT, but 250 plus VAT can get you started. All right. And I do know that there are certain financial institutions that do assist as well with having those things put in place, whether it's a will document, whether it's their legal department, whether it's their specific bank account or your specific bank account at a financial institution. There are areas where you can go to seek advice as it relates to your estate. All right. Now, at this time, I'm going to hand back over to the co-host of today, the host and co-host of today. And I want to say thank you so very much to all of you who would have participated. And I would also like to encourage you to take steps towards taking the future seriously, not only for retirement, but for every tomorrow that comes. All right, I'm seeing some questions coming in. I want to say to you, you're an awesome virtual audience. And at this time, we would want to hear your questions. So I will now hand back over to Miss Sheila Rosette. Sheila?
Thank you so very much, Gail. And we've come now to the question and answer segment of today's webinar presentation, where we engage with you, the participants. So yes, as Gail said, we do have some questions in. The first, one of our participants indicated that the probate process in Barbados could take to as much as 36 months. Gail had said it 2 years, but someone said it could take to as much as 36 months. And there is a question about probate. One of our participants wanted to know what is probate and why to avoid it.
All right, so probate is the process of having your estate, any assets, any bank accounts, any insurance proceeds, if there is no beneficiary, named beneficiary, no joint account holder, etc., where your estate now has to go through the court process. The court must now see how these accounts, how the assets, how the liabilities, etc., are going to be distributed or dissolved. So for in the example of you having a property and the property title deed is solely in your name, and you are a single individual who is not married, and there is no will document, the property needs to then be transferred. If the mortgage is cleared, the mortgage has been, you've paid off your mortgage, you've reached retirement age, you have lived the ripe old age, and you have passed away. All right, scenario. The property now needs to be transferred to someone else. And that process must go through the probate process, which is through the court system, where an executor from the court has to be appointed to have your property, your asset, transferred now to a family member. All right, so someone may come forward and say, okay, well, look, we're, the persons who will want to, we're living in the house, we would want to take over ownership of the house. How does that happen? All right. A lawyer may need to now be, not me, a lawyer will need to be involved in the process because title deeds need to be transferred from the deceased to someone who comes forward to say, we are now going to take ownership of the property. And those legal costs and those probate expenses can become extremely lengthy, one, and can become extremely expensive or costly. So in the example here that you've given of 36 months, that may be absolutely correct, because it may take 24 months for an executor to be appointed to the estate. But because an executor is appointed to the estate does not mean that the court process will hand over or do the paperwork or the legal process will happen in the next 2 weeks. It can very well be extended by another 12 months, which is 36 months. Sometimes it can be longer than that, depending on how many persons may be, quote unquote, fighting for the property. So you may have had an elderly, the oldest child come forward, and the oldest child wants to take ownership of the property. The younger ones are fighting to say, well, we deserve to have the property as well. That process can be a back and forth. Sometimes those persons are not living in Barbados. They may be living out of the island. you know, so it can take 36 months that you said. Why you want to avoid it? You want to make sure that you have things put in place to make sure that those costs, those legal expenses, those court process time frames are reduced as much as possible. All right, because that can cause some headache. It can cause some headache. So I hope that answers the question. It's a great question.
Okay, thank you. So we had two questions about trust. How much does it cost to set up a trust, and what is required to set up a trust?
All right, so that's a good question as well. Trusts are not as simple or as straightforward or as available. In Barbados, I do believe that there are institutions that would assist with the setting up of trust. However, trust can also be something that can be very costly as well to be able to maintain once the trust process does begin. That's something that I believe certain credit unions or certain trust aspects of credit unions may provide in terms of having proceeds paid to beneficiaries as per the deceased wish. So, for example, you may have had a trust, you may have had property in holding, you may have had accounts with, cash available, and you may say in your will document that you want your family members or you want a grandchild who, may have been 14 at the time not to receive these funds until they reach age 18 or until they reach age 24. While your will document states that the funds have to be held either at a bank account or in a trust fund, where then when that individual or that grandchild reaches age 18 or reaches the particular age, those funds are then paid out to the named beneficiary or to whoever it was supposed to be paid out to. All right. So in terms of setting it up, there are institutions here in Barbados who will assist with that. There's also attorneys who would assist with that, who would specialize in those particular areas. And in terms of the cost to manage the funds may very well depend on the size of the estate or the size of the trust fund at the time. So that's something that you may be able to ask or inquire about from an estate attorney. All right, so I hope that answers the question.
Okay, we also had a few questions about wills. So one participant wanted to know what constitutes a basic will, and another question was, why can a will be signed with an X?
Okay, so I'll answer the first question first. The components that I would have gone through just now are some of the components that obviously are necessary for a will to be documented. What makes up a basic will would be, for example, if you have 2 bank accounts, you have 1 property, you have a few life insurance policies, you may have beneficiaries, you may have 1 or 2 beneficiaries, there may be a property involved, and you may just be saying in this will document that you would want to have, these properties or these bank accounts or your assets, etc., transferred to the person's names or name, right, upon death. Okay, now what makes it a little bit more complicated is if in your will you are requesting for funds to be paid out upon some person's 25th birthday, or access to property or access to business or access to particular components have to then be done 5 years after, 10 years after. That has to be managed by someone. All right. If you have a collection of what we refer to as collectibles, so you may be some person who, looked after antiques or looked after a collection of antique vehicles, for example, worth hundreds of thousands of dollars. And you want those antiques, or you want those vehicles to remain within the family and not to ever be sold. Something like that, right? The more complex it gets, the more it may cost, because as an attorney, they may have a little bit more legal work to do in order to find out, you know, how these things are going to be distributed, when they're to be distributed, who they're to be distributed to, and what means they must be distributed via, whether it's via bank account, whether it's via written check, when they have to be distributed by. So those things make it a little bit more complex. With regards to signing a will by an ex, I am not sure what that is referring to. As far as I am aware, subject to correction here, signatures must match that of some person of the testamenters ID. All right, so once a will is being done, that signature must match the signature on that person's proof of identification, copy, whether that's a bank, whether that's a ID card, whether it's a passport, or whether it's a driver's license, or two of the three. So I'm not sure about it being signed by just an ex. Hope that answers the question.
Okay, there's another question relating to wills. In the case of a common law spouse, without one leaving a will, does your common law spouse automatically have rights to shared home fully owned by you after your death?
In the case of a common law spouse, I am subject to correction here, but there must be proof that that individual is a common law spouse. So typically you may have a JP, Justice of Peace, who might be able to verify that this individual was in fact a common law spouse. All right, might be classified as a common law spouse. However, if that is the case, then the property was solely owned by the deceased, there could also be legal complications in there aside from a note from a JP. All right, but that question might be better answered by an estate planning attorney or someone with, you know, a little bit more legal background that may be able to provide a clearer answer for that question. But it's a great question.
Okay, there was a question asking you to elaborate on POD with the bank. Elaborate with POD with the bank.
All right, so POD, just to recollect, POD is payment on death. Now, as you can imagine, when some person passes away, there must be proof of death as well. Proof of death comes by way of the death certificate, and that must be presented to the bank. You cannot just walk into an institution and say, well, my grandmother, my parent, my daughter, my spouse, whoever passed away. All right, there must be proof of death. If it has been set up prior to death that this payment must be made or funds must be transferred on death, then and only then can the bank recognize that this payment is supposed to be transferred. It has to be something that has to be set up from in advance. All right, so the bank must be aware of that. And also what needs to be noted here is that if the bank is not aware, it's not something that can happen automatically when you provide the bank with, or the financial institution with, the death certificate. All right. So that's something to take into consideration there. The financial institution, it will vary from, you know, financial institution to financial institution, and their legal department will then, you know, have an idea of when or how soon, how long it will take, things of that nature. That may be something that you can also research from now to find out if your current financial institution will facilitate things like that in the absence of maybe a will document or other legal documentation. All right.
And another question in relation to bank accounts: how could a creditor get to a joint account? Is there a legal right or legislation for a creditor to get access to personal or joint accounts?
All right, so this is another good question here, because typically as a creditor, as long as that creditor is owed money, right? The financial institution, obviously it depends on which financial institution you are with, and I speak subject to correction here. The creditor does have by all rights to access or request for the bank to pay the creditor to clear the loans or the debt. So for example, if your loan or if your debt, your mortgage, your credit card, etc., is not insured, the bank, or rather your estate, will seek to clear your liabilities first before your assets can be transferred. And in many cases, this is something that happens if, for example, let's give the example or scenario of a mortgage and a property. So if you know that if your mortgage is in arrears, or if your mortgage payment, let's say for example, you have 3 more years for your mortgage payment and that person passes away and it's not a jointly owned property, the bank can has all rights, although you may have paid them 10 years, right? 15 years out of a 20-year mortgage, the bank has by all rights to repossess your property. Why do they repossess the property? They repossess the property because the property owner, who has now become the deceased, is no longer able to make a payment. All right. So as part of their estate, they can now resell that property, right? And so them as the creditor, them as the person who you owe the money to, has access to that property so that they can regain the outstanding debt amount and resell the property, not just for the amount that they're owed, but for market value. And that's what happens in examples of a creditor being able to access your liabilities first and then assets to be distributed. So in the event of a joint account, if the joint account holder is not, or the surviving joint account holder who becomes now the sole account holder, does not have an interest or cannot contribute or pay that mortgage amount, funds in your bank account, any assets that you may have, the creditor by rights will have access to be able to take the assets against the liability. And that's the importance of having a life insurance policy, so that in the event that some person dies, your life insurance policy proceeds can clear off any outstanding debts, any mortgage, any credit card balances, etc., so that property specifically can remain within your household, can remain within your family. All right? Those policy proceeds is what helps in situations like these. It can also help in situations where legal fees need to be paid. And also in the situation where, as you were mentioning before, an executive may take 2 years, 24 months, 36 months, etc., to be appointed to an estate. That's a long time to go without a mortgage being paid. All right, without bills being paid, especially if that person was, a breadwinner of that household, etc. So it's a great question, but definitely it is something where thought must be put behind it. Because of the joint account holder, as I mentioned before, there are advantages and then there are also disadvantages where assets and liabilities are concerned as it relates to an estate. All right, I hope that answers the question.
Okay, there are a few questions about insurance. One of them is: you have a life insurance policy, no beneficiary is named, your family is unaware of the policy, to whom do the funds go?
All right, so I'm seeing some, if I may call it, red flags here. There's some red flags here. The first thing is that if you have a life insurance policy, there must be a named beneficiary. All right. If this is not, or if there's not a named beneficiary attached to your life insurance policy, that's something that should be worked on as of today. All right, just make sure that that named beneficiary is some person that is trustworthy, is some person that's over the age of 18, because life insurance policy proceeds are not to be paid out to minors, or depending on the institution, will not be paid out to a minor. That's number one. Number two, what happens in the event of death and the family members or whoever does not know of your insurance policy, the insurance company will wait until your estate, or whether there's advertisements being placed in the newspaper, where we will check to see whether that person has passed away, etc. Sometimes persons may come forward months after, and they're cleaning up and so on, they come across your policy contract document they were not aware. They may come to the insurance company, and if there was no beneficiary, then those funds also have to go through the probate process, where the estate, the court process, or the probate process will then determine who comes forward to claim your estate, and then and only then will the insurance policy proceeds then be paid out to someone. All right, but that must then go through the probate process, which can take, like I said, 24 months, 36 months, etc. And that is why it's important to have a named beneficiary on your insurance policy. All right, because if it's not a named beneficiary, it goes towards the estate, and the estate has to go through the court process, and the court process can take a very lengthy time. If there is a named beneficiary, it avoids the probate process, and those funds obviously come to beneficiary or beneficiaries as tax-free income, all right, as a lump sum payment. I hope that answers that question as well.
Okay, there's another question in relation to insurance. So this is health insurance. How do you manage those payments at retirement? The cost can be prohibitive at the time that you need most coverage.
Yes. So for health insurance, if you've had your health insurance policy prior to retirement, then the cost that are associated with your health insurance may either remain the same depending on which institution you are with. The tricky part, or the challenging part, comes when you are going to retire and you are now looking to enroll in a health insurance policy. I believe that there are institutions like BARC, for example, who may have very decent rates, etc. However, there are also other considerations as it relates to health insurance costs and being eligible for the health insurance, etc., which obviously would depend on your age. It would also depend on your current health. It would depend on a number of different factors as well. But that's one of the things that comes along with old age, that you want to plan from years gone by, and not just wait until retirement or retirement age to enroll in health insurance. All right. I hope that answers that question as well.
Okay, thank you, Gail. There's another question on wills. If there was no will, how would the estate be divided, especially if the deceased has a spouse?
All right, so typically a spouse becomes the first person, right, for the estate to be transferred to. However, there are scenarios where if the spouse was not the first spouse and there's children from previous relationship, or there may be other factors there that may need to also be taken into consideration. But if there was no will, the estate can typically be transferred to the spouse alone. that's something that an appointed executor can decide upon the dissolving of that estate. All right, so if there's no will, then the executor is the person then that would decide how the estate will be divided, whether it's just the spouse, whether it's spouse and children, things of that nature.
Okay, we're winding down. I'm just scrolling through to see what other questions we can answer before we close our session. Okay. All right, this is another one in relation to mortgages. What advice can you give about reverse mortgage? Can it be used for asset management?
I am not particularly certain, and this may not be a question that I might be able to answer. I am not particularly certain whether reverse mortgages are applicable here in Barbados. So it's something that's definitely done in the United States, but I cannot speak to whether it is something that is done here. All right, so I may have to, that may be something that I may have to do some research on, and if anything, come back to you about, just to seek some further clarification. But I do know it's done in other parts of the world. I'm just not sure why there's something that is done here. But certainly if it can be done here, I would imagine that it could help with estate planning, yes. But I am not certain as to why there's something that can be done here. So I wouldn't be able to speak to that.
Okay, I will take two more questions. If the pensioner dies, what happens to underage dependents? Can they get survivor benefits?
Yes, so there must be proof of that pensioner taking care of or being responsible for a minor, right? Whether it's a minor child or grandchild, there must be proof of either guardianship, there must be proof of that pensioner providing financially for that individual before NAS can provide them with survivorship or survivor benefits for an extended period of time. I do know that certain things must also be factored in. So if that minor child is in school, up to maybe tertiary level education, if they stop tertiary level education or graduated from tertiary level education, some of those benefits may also start from NAS. But that's as much as I would know as it relates to survivor benefits for minor children as it relates to NAS.
Okay, all right, we take one last question. It's in relation to bank accounts. If a bank doesn't have creditor life insurance available for you to apply to your account, how can you get that type of insurance assigned to your debt or other accounts to avoid any hassle for your family members upon your death?
All right, so typically if the institution does not provide the creditor's life, the next easiest or cheapest option, depending on your age, depending on health status, etc., is to apply for a term insurance policy. A term insurance policy is one that is a basic life insurance policy. It covers the amount, provides you with the value of the amount that your mortgage balance is, so that in the event of death, the proceeds are paid from the insurance institution directly to your financial institution to clear off the balance of the mortgage upon death. However, understand that there is no assignment of beneficiary. If the term insurance policy needs to be assigned to the institution, the institution becomes the estate. So the insurance proceeds will be paid directly to that financial institution because the policy has been assigned to that institution, particularly for the mortgage. All right, there are obviously different types of insurance policies and there are different options, etc. But that would be the most common option for mortgage collateral or mortgage insurance.
Okay, so we have come to the end of the webinar presentation for today. To our presenter and facilitator, Mrs. Gill Worrell, a very hearty and sincere thank you for making this journey with us over the past 3 weeks. It was indeed a pleasure interacting with you. I'm sure that I can speak on behalf of the attendees in seeing that a wealth of knowledge was shared. We are all truly appreciative. Thank you very much as well to my co-host, Mr. Mark Hurley. Your assistance and support are greatly appreciated. To today's attendees, I thank you so very much for your questions and contributions, and any questions that remain unanswered will be forwarded to the facilitator, and her responses will be shared with you via email. The link to our evaluation form is going to be placed in the chat, and we thank you in advance for your feedback, which is of great assistance to us as we plan for future webinars. I also want to share with you that the Learning and Development Directorate had a webinar on the awarding of retirement benefits under pension at CAP 25, and it was presented by my co-host, Mark Hurley, and it can be viewed on the Learning and Development Directorate's YouTube channel, and it is complementary to what would have been shared over the last 3 weeks in this series on retirement planning. So you can log on to LDD's YouTube channel and have a listen to continue to expand your knowledge on retirement planning. Thank you so very much again for joining us today. The session will remain open for a few more minutes to allow you to access the evaluation form. On behalf of the Learning and Development Directorate, I extend best wishes to everyone for a pleasant and productive remainder of your day.